we have major breaking news. There are a series of major petitions for certiorari that have been filed to the United States Supreme Court, asking the Supreme Court to take a quote-unquote assault weapon ban case, either dealing with bans on semi-automatic rifles or magazines that hold more than 10 rounds. These petitions have arisen, as you know, last week from the Bianchi case dealing with Maryland's assault weapon ban out of the Fourth Circuit Court of Appeals. And now there's a series of petitions that have been filed arising from the United States Court of Appeals for the Seventh Circuit. That's the Judge Easterbrook panel out there in Chicago. All of this is before the U.S. Supreme Court, waiting for the Supreme Court to act or choose not to act. This is a big deal, but let me break it down for you because it's a little confusing, but don't worry, I will make it easy to understand in one moment. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so a lot of complicated stuff going on before the U.S. Supreme Court involving semi-automatic rifle bans and magazine bans. Specifically, there's a series of petitions for certiorari that have been filed by a series of major Second Amendment law firms and Second Amendment lawyers. Very powerful briefs to the U.S. Supreme Court, asking the Supreme Court to take these cases dealing with Illinois and Maryland's quote-unquote assault weapon bans on the grounds that the lower courts, the courts of appeals, are simply blowing off U.S. Supreme Court precedent, specifically the Heller decision. As you know, the Heller decision in 2008 by the U.S. Supreme Court said that arms are anything that can be used offensively or defensively. And the arguments before the U.S. Supreme Court in all of these cases, and there's 4 of them right now by my count, are arguing essentially the same gist. They're all basically arguing what I have explained to you is the right position to argue on this channel, which is that step 1, that you argue that arms are anything that can be used offensively or defensively. That's not my interpretation. That's not even the Supreme Court's interpretation. It is the Supreme Court's interpretation based upon 18th century lexicographers who wrote dictionaries that said that arms at the time of our founding in 1791 are defined as anything that can be used offensively or defensively, which obviously includes all types of firearms. So since semi-automatic rifles and magazines that hold more than 10 rounds are arms, magazines are arms because they are a necessary component of a modern-day firearm, and they facilitate self-defense, no different than a barrel or a firing pin or a trigger or stock or a bullet. All of these things are necessary components or important components to a modern-day firearm, and thus they are defined as arms under the doctrine of concomitant rights, sometimes referred to as ancillary rights, meaning things that are essentially an essential component of a right. So for example, in the First Amendment, the right to free speech and the right to free press protects ink. We know that from the 1983 Supreme Court case of Minneapolis Star that said attacks on ink violates the First Amendment, even though the word ink does not appear in the text of the First Amendment. So too, when we're talking about magazines, bullets, barrels, suppressors, I would argue, triggers, and so on, these are all concomitant rights or ancillary rights or part of the text of the right to keep and bear arms, because a violation or taking any of these things away hinders the right to keep and bear arms and thus constitutes an infringement, and thus the right of the people to keep and bear arms shall not be infringed, has been infringed by virtue of taking away any of these items, including, again, magazines that hold more than 10 rounds. So with that said, as a matter of text, magazines that hold more than 10 rounds as well as semi-automatic rifles are protected arms. So then we go to the historical test. The burden shifts to the government, and then we go to the historical test. And this is where my article, which I should note is cited by several of the major briefs in these cases before the U.S. Supreme Court right now, that points out, it's not my opinion, it's clearly what the Supreme Court has said. I'm just reiterating and pointing out what the Supreme Court says. Clearly says that the Heller decision in 2008 is the law of the land. It sets forth the constitutional standard for how courts, including inferior lower courts, are to interpret the Constitution and determine gun ban or arms ban cases. And because these cases out of Illinois, out of California, out of Maryland are banning a type of arm, i.e. semi-automatic rifles or magazines that hold more than 10 rounds. These are arms ban cases, and because these are arms ban cases, Heller controls. Keep in mind that Bruen decided in 2022, cited favorably the Heller decision about 80 times, by my count, 80 times. And not once did Bruen do anything to cut back or suggest that the Heller precedent is not good law or is narrowed or anything in that respect at all. So Heller remains the law of the land when it comes to arms ban cases, and that's what all these briefs essentially are arguing. They cite to my article in the Harvard Journal of Law and Public Policy to make this point, and then they go on to say that because semi-automatic rifles and magazines are arms, the burden shifts, and they're now being banned, the burden shifts to the government to show that there's some historical tradition here, but there is no historical tradition we need to worry about because the Supreme Court has already done the work and figured out the historical tradition. They said that whatever the historical tradition is, conceptually, it is that you could conceivably ban arms that are dangerous and unusual. Dangerous and unusual, conjunctive has to be both. And the Heller case went on, in the case of a handgun ban by the District of Columbia, went on to say that because handguns are ubiquitous and owned by millions of Americans all across the country, their most popular weapon used for self-defense in America, they're clearly in common use. And because they're in common use, it is simply impossible for the government to satisfy the government's burden that these weapons are dangerous and unusual because they are clearly in common use, and because they're in common use, they are not unusual, and thus there's no way for the government to satisfy the historical constitutional standards set forth in Heller of dangerous and unusual, because since these weapons are in common use, they're not unusual, and thus they cannot possibly be dangerous and unusual under any definition. So all of these arguments are essentially articulated in powerful briefs by the lawyers in these cases. Now, I should mention the names of the 4 cases just for the record. We know the Bianchi case, which is Bianchi versus Brown out of the 4th Circuit Court of Appeals. That's the Maryland assault weapon ban. Again, propaganda term, assault weapon is anything can be an assault weapon, including a spoon. That's a propaganda term by the left. We know that. And the 3 cases so far, by my count, that have come out of the 7th Circuit Court of Appeals in that terrible decision by Judge Wood and Judge Easterbrook, 2-1 decision against the Second Amendment that just literally made stuff up and flouted entirely the Second Amendment precedents of Heller and even Bruen. Just a pathetic opinion. We've talked about that in detail in this opinion or in this channel. But again, the 3 cases here are Harrell versus Rao, Bevis versus City of Naperville, and Barnett versus Rao. Now, I should mention that some of the most powerful lawyers in the Second Amendment community are on these briefs asking the U.S. Supreme Court to take these cases. Cooper & Kirk, major law firm in the Supreme Court bar, is on one of these briefs. Chuck Michelle out of California and his firm is on another one of these briefs. Paul Clement and Aaron Murphy, 2 of the most important constitutional lawyers in the country who've argued Heller. Paul Clement argued Heller and Bruen, are on one of the briefs in the Barnett versus Rao case. Barry Arrington is representing the National Association of Gun Rights. The Second Amendment Foundation is involved. The Firearms Policy Coalition is involved. The National Shooting Sports Foundation is involved. So basically all the heavy hitters in the Second Amendment community are on one or more of these various briefs in these various cases. So this is important because part of what the Supreme Court looks to and whether or not they grant cert is who are the lawyers. There's no doubt that the quality of the lawyering and the quality of the lawyers on these briefs is very high, so that should not be a roadblock. Now, in light of all this, what do I think is going to happen? Well, let me give you the good news, and then I'll give you the potential bad news. The optimistic look is this. The optimistic view is that given the fact that the lower courts, the 9th Circuit in California, the 7th Circuit out of Chicago, the 4th Circuit out of Maryland, are simply playing games and not applying Heller correctly, and they're not even trying to, as best anyone can tell, and they're playing these procedural games with en banc review and so on and so on. And given the fact that the lawyers are all lined up, this is a very easy, straightforward case. I think there's a real chance that the Supreme Court might take one of these cases and resolve this question of whether or not a semi-automatic rifle is a protected arm in the same way that semi-automatic handguns are protected arms under the Heller precedent. It seems odd that Heller would say that modern handguns are protected arms, but not modern rifles, given the fact, not that you're supposed to do interest balancing here, but if you just think about it, the number of people killed with handguns by people wielding handguns far exceeds by orders of magnitude the number of people killed in and around all long guns in any given year. There's something like 300 people are killed with all long guns in the United States, and there are tens of thousands of people that are killed with people using handguns. So it's not even close from any kind of arguable public policy consideration. But again, legally, none of this matters. But it just seems odd that semi-automatic handguns are protected under Heller, but semi-automatic rifles would not be. So this should be an easy layup case in favor of the Second Amendment community, but only time will tell. So the optimistic view is it's an easy case. It's a lot like Caetano dealing with stun guns, where the lower courts are clearly screwing stuff up, and therefore it's an easy case to take, issue a decision based on Heller and Caetano, rule in favor of the Second Amendment, and be done with it once and for all. So and they got the lawyers, the powerful, smart Second Amendment lawyers are in front of the Supreme Court on this case, so they know the lawyering is going to be strong and good. So that's the optimistic view. Now the pessimistic view is this. As I've told you before, the Supreme Court, generally speaking, does not like to take cases on an interlocutory basis. An interlocutory basis simply means it's an appeal that's taken in the middle of a case and not at the end of the case. All of these cases we're talking about, the Harrell versus Rao, the Bevis versus City of Naperville, Barnett versus Rao, the Bianchi case out of the Fourth Circuit, these are all cases that right now are in a procedural posture of being interlocutory, meaning there is no final judgment. And as I've told you before, these courts of appeals, in my opinion, hate guns, do not like the Second Amendment, are desperately hoping to buy time to prevent the U.S. Supreme Court from deciding one of these cases, because they hope that the Supreme Court's composition changes, either because Justice Thomas or Justice Alito gets swapped out for another Brown Jackson or Justice Kagan or some other Biden pick, or they get to expand the number of seats on the Supreme Court. That is the Democrats' goal and wish, to control the Supreme Court, so they have a monopoly on all aspects of government. So these lower court judges, I should say, not justices, judges, are dragging their feet as long as possible, hoping that somehow something breaks their way and the composition of the Supreme Court changes. That is the reality on the ground, in my view. I feel very strongly I am correct. That is my professional view as to what's going on here. It may seem cynical, but hey, I'm a realist. I have to play in the real world. I can't live in a fantasy world and just wish for good things. I have to try to make them happen, and I do that with this channel and more. So anyway, so optimistically, there is a chance, I would say maybe a 20-25% chance one of these cases goes to the Supreme Court. If it does go, we are 100% going to win the case, and it will be a major win for the Second Amendment. So let us hope one of these cases is granted cert. We got our fingers crossed here. Now, let me give you, again, the pessimistic view is, because these cases are on an interlocutory basis, the Supreme Court may simply deny cert, saying go back and get a final judgment and then come talk to us. There's been no indication that I can tell of the current Supreme Court wanting to take one of these cases. They're not really reaching out to grab one so far. So that's not a great sign. And again, just statistically speaking, I think, again, we're looking at maybe a 20-25% chance that one of these cases is taken, this or the Bianchi case or one of the Seventh Circuit cases. But again, I'm not sure that's going to happen. If the Supreme Court denies cert, now here's another possible positive. If the Supreme Court denies cert now on the grounds that these are all in an interlocutory stage, what might be a favorable outcome in the event that cert is denied and they go back to the lower courts for further consideration is if we were to get some very favorable dissents from the denial of cert, from Justice Thomas, Justice Alito, Justice Kavanaugh, Justice Gorsuch, whatever, basically indicating to the lower courts that Heller is the law, they're watching you carefully, they expect you to apply Heller and to do your job. If you get a dissent from the denial of cert like that, then that could be a positive development, because it may force the lower courts to look carefully at the dissent and realize they're being watched. It will likely get reversed if they screw up. Again, that's not optimal, but that's possible and possibly a positive, although not the optimal outcome. The optimal outcome is the Supreme Court grants cert, and here's the Second Amendment case next term, and rules in favor, which they should, that AR-15s, AK-47, semi-automatic rifles, magazines that hold more than 10 rounds are protected arms, and they're in common use and thus simply cannot be banned by any of these states. That is, of course, what we want. As to whether or not we get there in the next 12 to 14 months, we will find out. We're certainly going to know a lot more about what the Supreme Court thinks about these cases, given the fact that everybody in the Second Amendment community is up in front of the Supreme Court asking for them to take this on the grounds that the lower courts are simply thumbing their nose at Supreme Court precedent. The metaphor I like to use here, I don't want to blend a couple popular cultural references, but I'm going to. If the Supreme Court of the United States, in my opinion, was full of people like Travis Kelce, the tight end for the Kansas City Chiefs, who dates Taylor Swift and is obviously an extremely aggressive individual, if you saw his interplay with his coach, Andy Reid, at the Super Bowl, well, I would say if the Supreme Court were aggressive in defending their rulings, their precedents, their institutionalism, if you want, their institutional integrity and so on, then I would say a Travis Kelce aggressive person, jurist, would step up and defend the Supreme Court robustly. They would grant cert and they would fix this problem dealing with semi-automatic rifle bans and magazine bans right here and right now. On the other hand, if the Supreme Court wants to embrace a paradigm more along the lines of, let's say, George McFly from Back to the Future, that would be Michael J. Fox's father, Marty McFly, and the father was George McFly. At the beginning of Back to the Future, you might remember he was not exactly a particularly impressive, powerful individual. He was kind of bullied and beat up quite a bit. If the Supreme Court wants to adopt that attitude or that paradigm as to how they're going to protect their precedents, then protect their institution from lower court massive resistance, well, there's nothing you and I can do about it because we're not in the Supreme Court. So again, as to whether or not the Supreme Court embraces a Travis Kelce approach or embraces a George McFly approach, only time will tell. But if I were on the court, I would be in the camp of Travis Kelce, but I'm not on the Supreme Court, so it really doesn't matter what I would do. But certainly I would aggressively protect the institution that I serve. And hopefully Chief Justice John Roberts sees what's going on in the lower courts and steps up and does the right thing. But only time will tell to see if that happens. So there you have it. All right, folks, hope you learned a little bit something here today. Obviously, we're going to track all these cases carefully, but that's where things stand. Don't forget to follow me on X at 4boxesdarn, and make sure you subscribe and resubscribe here. People keep getting knocked off, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.